All right, so imagine this, right? You landed an amazing new gig, paperwork's all signed, sealed, everything's ready to go. But then
The one document.
that crucial document
Hmm.
that makes it official, it never actually gets to you.
Ah, the
And you're
frustration.
stuck, right? This is the story of Marbury v. Madison,
Oh,
one
yes.
of the most impactful Supreme Court cases in U.S. history.
And this is a perfect example of a case where it seemed small at first, but then just ballooned
Yes.
into something huge.
It wasn't just a matter of, did these guys get their jobs?
Right.
It fundamentally changed the way the whole U.S. government functions. And, we're still dealing with the fallout from this case today, centuries later.
Right.
So we've been digging deep into the original Supreme Court decision for this deep dive, the Marbury v. Madison 5 U.S. 137.pdf. And we want to really break down these core questions that the court had to grapple with. Did William Marbury and the other appointees actually have a right to those commissions?
Mm-hmm.
If so, was there a legal way for them to actually get them? And could the Supreme Court itself step in and make that happen?
A big question
Huge question.
with even bigger implications.
Absolutely. So think of this deep dive as your crash course on understanding this cornerstone of American judicial power.
Exactly.
So to kick things off, who exactly was William Marbury and what was he trying to do?
Right. Well, let's set the stage. It wasn't just William Marbury going it alone.
Oh, yeah.
You had Dennis Ramsey, Robert Townsend Who, and William Harper. They were all in this together. Now, these guys, these weren't just random folks. They'd been nominated by the outgoing president, John Adams, right at the end of his term back in February 1801 to be justices of the peace for the District of Columbia.
So this wasn't just like a handshake deal.
Oh, no. This was official.
It was the real deal.
This was the Senate giving their official advice and consent. It was the president, John Adams, signing the commissions, the Secretary of State at the time, making it official by putting the Great Seal of the United States on these documents. Everything was done by the book.
So on paper, they're good to go.
It should have been a done deal.
Right.
But here's where things get interesting.
Here comes the snag.
These commissions were never delivered. Never made it to Marbury or the others.
And then what happens? A new administration rolls in.
New sheriff in town.
Thomas Jefferson takes the helm. James Madison becomes the new Secretary of State. And when Marbury and the others quite reasonably ask for their commissions.
Yeah, like, hey, where's our stuff?
Right. What happens?
Crickets. Nothing.
Madison basically just ignores them.
Stonewalled.
And, it's interesting to see how much effort Marbury and the others put in to trying to sort this whole thing out. They go back to Madison's office multiple times, trying to just get some basic information about their commissions, and they hit a brick wall.
You can really feel their frustration reading through the source material.
Oh, absolutely.
It must have been infuriating.
Totally. They even try to go through official channels, like reaching out to the Secretary of the Senate to confirm their nominations, but that leads nowhere as well.
So ultimately, they're forced to take a pretty drastic step.
They had to pull out the big gun.
They had to subpoena witnesses to try to uncover what exactly happened to their commissions. They just wanted answers.
And they weren't getting them any other way.
Nope.
So facing all these roadblocks, Marbury and his legal team turned to the courts,
Makes sense.
seeking a writ of mandamus. And for those of us not in the legal field, can you break down what that actually means in this context?
Sure. In simple terms, a writ of mandamus is like a court order. It tells a government official, hey, you got to do this specific duty that you're legally obligated to do. In Marbury's case, his lawyer, Mr. Lee, argued that the Secretary of State, James Madison, had this non-discretionary duty, they call it a ministerial duty, to deliver these signed and sealed commissions. Think of it like the Postal Service. Once a package is properly processed, they have to deliver it. No ifs, ands, or buts.
Okay, I'm following. So let's unpack this idea of a ministerial duty a bit further. So Mr. Lee's argument hinges on this distinction between whether the Secretary of State was acting directly on orders from the president, like following instructions, or if they had these specific duties laid out by law that they had to perform, regardless of what the president said.
Right.
And they argued that handing over these commissions, especially since these were for justices of the peace in D.C., with a set 5-year term, as stated in the Act of February 27, 1803, mentioned in the document,
Right.
that this fell under the gotta do it regardless category.
It's not like these were positions that served at the pleasure of the president. They had a fixed term. But
Exactly.
once that appointment was made, it was made.
And it's not like they were making it up as they went along. They even point to a specific law.
Oh, yeah, the Act of September 15, 1789.
Right.
This law outlines some of the Secretary of State's responsibilities, keeping the Great Seal safe, and importantly, putting that seal on civil commissions after the president signs them.
It's all there in black and white.
Exactly. Their legal argument was that once the president signs and that seal is attached, delivering the commission for a fixed-term office like this, it becomes a required action, a ministerial act. The paperwork's done. The only thing left is handing it over.
It does seem like a pretty open and shut case.
Hmm.
The documents are there, just deliver them. But as we know, law is rarely that simple. Marbury's lawyers even dug up past legal cases and principles from English common law and previous practices in the U.S., though the court ended up differentiating those examples from this case. And they even brought up specific instances where a mandamus had been used, like compelling a government official to perform a specific duty, even if other legal options might technically exist.
And to really get to the bottom of what happened to these commissions.
Right, did they even exist?
Exactly.
The court did something pretty unusual. They heard firsthand accounts and reviewed the evidence.
This is where the story gets really interesting.
It really does feel like we're getting a peek behind the curtain right into the inner workings of the case.
Absolutely. So they brought in these clerks from the State Department, Mr. Wagner and Mr. Brent. Wagner couldn't specifically recall seeing Marbury's commission, though he did remember Marbury and Ramsey asking about them. And he vaguely recalled saying that 2 were signed and 1 wasn't, but that was based on something someone else had told him. Crucially, he wasn't even sure if any of the applicants' commissions had ever been officially logged.
Okay, so a bit hazy on the details there. What about Mr. Brent?
Well, Brent's testimony was a little more concrete. He said he was pretty sure that commissions for both Marbury and Who had been made, but that Ramsey's was probably missed because of a mix-up in the list of names he had prepared. Interesting thing is, he also testified that he didn't think any of the Justice of the Peace commissions signed by President Adams were ever officially recorded or even sent out. So they were prepared, but they just kind of sat there.
Gathering dust.
It seems that way.
Then comes this dramatic entrance of Attorney General Lincoln.
Oh, yeah, this is good.
He'd actually served as Secretary of State during the transition from Adams to Jefferson.
Right in the thick of it.
Right, and he's initially really hesitant to testify, citing executive privilege, this idea that the executive branch can keep certain conversations private, and he even brings up concerns about self-incrimination. You could just imagine the tension in the courtroom.
It's a real whoa moment.
Totally. But the court stands firm, right? They make it clear that while some executive communications need to stay confidential, the basic question of whether these commissions actually existed wasn't one of them. Lincoln didn't have to reveal anything truly secret or self-incriminating, but the basic facts, those were fair game for the court to look into.
They needed to get to the bottom of it.
Exactly. And so Lincoln finally does testify. He admits to seeing signed and sealed commissions for justices of the peace in D.C., but can't specifically remember if Marbury's was among them. But he does back up Mr. Brent's statement that none of those commissions were actually sent out to those appointed.
Right, so more confirmation that they were prepared but not delivered.
Right. And then they hear from James Marshall, who says that on March 4th, 1801, literally the same day the new administration started, he got around a dozen Justice of the Peace commissions for Alexandria, and he thinks Who's and Harper's were in there. But realizing he couldn't deliver them all himself, he returned some, crossing out the names on the receipt, and he thought Who's and Harper's were among those he returned. So piecing together all this testimony, it seems pretty clear that Marbury's commission had actually been signed and sealed, even though it never got to him.
Right, so the mystery is partly solved.
Right, which brings us to the heart of the Supreme Court's decision. They framed it around 3 fundamental questions. First, did William Marbury actually have a legal right to this commission he was asking for?
Okay, so on that first question, the court was crystal clear. They lay out the established process for appointments. You've got the president nominating, the Senate confirming, and then the president signing and the Secretary of State officially sealing the commission. And they say flat out that the appointment is legally finalized as soon as the president signs and the U.S. seal is on there. That's the point of no return, legally speaking.
So what about the argument that the commission wasn't actually official until it was physically handed to Marbury, or he formally accepted it?
Yeah, they addressed that head on. The court brought up this interesting comparison to letters patent, which are basically official documents from the government granting rights or titles. And they said that formal, in-person delivery isn't always needed for these kinds of documents to be legit. They argued that once the president had signed and the seal was attached, the executive branch had done everything officially required to make the appointment final.
So they were saying that Marbury basically didn't have to physically hold the commission for it to be legally his.
Exactly. And they concluded that since those key steps had been taken, especially given that the justice of the peace position had this fixed 5-year term, Marbury had this legally protected right to that job. The new administration couldn't just wave their hands and make that appointment disappear.
It sounds like a pretty clear win for Marbury on that first question. He had a right, and it was being denied. So then the second question the court tackles is this. If he has this right, and the fact that he didn't get the commission is a violation of that right, do the laws of the land provide him with any kind of legal remedy to fix this wrong?
Right, and here's where they dive into some really bedrock legal principles that have been around for ages. They even quote this famous legal scholar, Blackstone, who basically said that every legal right should also have a way to deal with it if it's violated. They argued that the U.S. government is all about being a government of laws and not of men, meaning that even government officials have to answer to the law. And withholding a commission for a right that's already been granted, that should have a legal solution.
So it's not like the government can just do whatever it wants.
Exactly. And they make this crucial distinction between a real legal injury and what they called damnum absque injuria, which is essentially a loss or harm that doesn't involve a violation of a legal right. They said that a public office like Justice of the Peace isn't just some trivial thing. It's important, it has value, and it deserves legal protection.
It's not just a matter of hurt feelings. It's about upholding the law.
Right. And they go on to reason that delivering the commission in this specific case was what they call a ministerial act, not something that the executive branch could just decide on a whim based on their political views. To drive home this point, they use these hypothetical examples like a government official refusing to properly record a land deed. The principle here is that even high-ranking officials are bound by the law when it comes to these clearly defined, non-discretionary duties. So the court concludes that Marbury was absolutely entitled to a legal solution to address the fact that his commission was being withheld.
Okay, so we've established two things. Marbury had a right, and there should be a legal way to address the violation of that right. And this leads us to the truly monumental question, the one that makes Marbury v. Madison such a landmark case. If the laws do provide him with a solution, is a writ of mandamus issued directly from the Supreme Court the right solution in this specific instance?
This is where the story takes a turn, and we really see the significance of the case unfold. The court starts by restating the definition of a writ of mandamus, citing legal heavyweights like Blackstone and Lord Mansfield, highlighting that it's basically an order from a higher court forcing a lower-ranking official to do a specific duty. They acknowledge the obvious political tension surrounding this case, but maintain that their job is to decide on the legal rights of the people involved, not to meddle with legitimate political decisions made by the executive branch. And they emphasize again that the duty to deliver the commission in this case was ministerial, not discretionary.
Right, so it wasn't about overstepping boundaries or interfering with politics. It was about upholding the law. But then they hit this major roadblock, don't they? It's not just whether a mandamus is the right solution in theory, but whether the Supreme Court actually had the power to issue that specific order in this particular case.
You hit the nail on the head. And this is where they dive into this crucial difference between original jurisdiction and appellate jurisdiction, as outlined in Article 3 of the U.S. Constitution. Original jurisdiction means a case can come straight to the Supreme Court the first time around. Appellate jurisdiction means the Supreme Court can only review decisions that have already been made by lower courts. The Constitution has a specific list of cases where the Supreme Court has original jurisdiction, and it's a pretty short list, mostly about disagreements between states or cases involving ambassadors and other high-ranking diplomats. Everything else falls under the court's appellate jurisdiction. Think of it like this. Original jurisdiction is starting a video game at the hardest level, while appellate jurisdiction is like watching a replay of someone else's game that they already played on an easier level.
Okay, I get the analogy. So where does the conflict come in?
Well, the Judiciary Act of 1789, a law passed by Congress, specifically Section 13 of that law, tried to give the Supreme Court the power to issue writs of mandamus to any courts appointed or persons holding office under the authority of the United States. That would include someone like the Secretary of State, in this case, James Madison, giving the Supreme Court original jurisdiction to issue that mandamus to him.
So there's the clash. The Judiciary Act is saying one thing, but the Constitution might be saying another.
Exactly. And the court, led by Chief Justice John Marshall, sees a direct conflict between this part of the Judiciary Act and the limits placed on the Supreme Court's original jurisdiction by the Constitution itself. They say that if Congress could just pass a law to expand the Supreme Court's original jurisdiction beyond what's specifically listed in the Constitution, then those limits wouldn't mean anything. In their view, the Constitution lays down the ground rules, and regular laws can't contradict those rules.
And this is where judicial review comes into play, right? The power of the courts to look at laws passed by Congress and decide if they're in line with the Constitution. It's a power we take for granted now. But Marbury v. Madison is where the Supreme Court truly claims this power for itself.
Absolutely. And the court's written decision on this is powerful. They declare that the Constitution is the top dog, the supreme law of the land. If Congress passes a law that goes against the Constitution, it's no good. They also emphasize that all judges swear an oath to uphold the Constitution, so they have a duty to defend it, even if it means shooting down a law passed by Congress. Chief Justice Marshall's famous line, "It is emphatically the province and duty of the judicial department to say what the law is." That's a bold statement about the role of the courts in our government.
It's a huge statement. So putting it all together, Marbury had a right to his commission, and there should have been a legal way to fix the fact that he wasn't given it. A writ of mandamus could have been that solution, forcing Madison to hand it over. But the Supreme Court decided that the specific law giving them the power to issue that mandamus, in this case, that part of the Judiciary Act, was unconstitutional because it went too far, beyond what the Constitution allows. So while Marbury had a right, and there should be a remedy, the Supreme Court couldn't provide that specific remedy he was asking for.
Right. They couldn't issue the mandamus because the law that would have given them the power to do that was itself unconstitutional. Their hands were tied.
So what happened in the end?
The court's final decision, the rule was discharged, they wouldn't issue the writ.
So Marbury never actually got his commission.
Nope, he didn't.
So the big takeaway for our listeners from this deep dive into Marbury v. Madison is this. Even though Marbury didn't win his case, this whole ordeal set up this hugely important principle of judicial review. It basically reshaped the balance of power in the U.S. government, giving the Supreme Court the power to say what the Constitution means and to overturn laws passed by Congress if those laws violate the Constitution. The real aha moment is that the court said, we get to decide what the law is, and that even applies to acts of Congress.
And there's this amazing irony in all of this, right? Marbury, just wanting his job, ended up losing his own case, but by doing so, he accidentally played a huge role in establishing the long-term power of the Supreme Court. It's kind of a wild twist of fate.
It really is. It's one of those surprising but crucial details that makes history so fascinating. And this isn't just ancient history either. Judicial review is alive and well, and it's constantly coming up in today's legal and political debates about how we understand and apply the Constitution to the challenges we face right now.
And this brings up a big question for everyone to think about. What would the American legal system look like today if the Supreme Court didn't have this power of judicial review? It's essential for protecting the Constitution, but it also potentially creates tension with the idea of the will of the people, the laws that our elected representatives make. It's a really important question that forces us to think about the very foundation of our government and how power is balanced within it.
Absolutely. It's food for thought for sure.
Definitely.
All right. Thanks for joining us for this deep dive, everyone.
Until next time.